Welcome to the next episode of Deep Dives by MIT Bootcamps. This is a new e-learning series that focuses on domains of expertise. Today we'll be responding to questions that you have shared online on what entrepreneurs need to know about intellectual property law. We received a significant number of questions. Some of them required additional clarity. So we would ask if you could please provide additional context into the questions that you're asking. That would be greatly appreciated. Or if you would prefer to email us directly, our email address for questions is bootcamp@mit.edu. Please note in the subject line, intellectual property deep dive, so that we can sort that out and send it on to Jim. And without further ado, here's Jim.
And good morning again. We received either 75 or 76 questions, I'm not quite sure which, and they ran the full gamut. Those I think I can answer, those I'm going to have trouble answering, those that are global significance, and those that frankly are specific points to which the answer is not that easy to find generally. I've tried to sort the questions out into sort of categories, some of which I can deal with together and some which I can't. And the starting question here is probably the most important one for you to look at all the way through. Is it always necessary to patent? I can simply say no and move on from there, but that's not going to do you much good. The answer is, though, no. Patenting, should you patent, what to patent, is always an important and not easy cost-benefit analysis. What's a patent going to do for you? What will it not do for you? What might it cost? Unlike trade secrets or copyrights, patents aren't free. It's very easy to spend more than $50,000 on a US patent before you get it. It's easy to spend between $500,000 and $1 million if you want to take that patent worldwide. Those are significant expenditures, particularly for a small company. As it happens, the next lecture session will deal with this question of what is a useful patent, when is it worth trying to get one, and when is the cost worth it. That's going to be a major subject in the next one, so I'm not going to any detail right now, but you'll come back in about 2.5 weeks and we'll spend the better part of half an hour on that subject. Next question was, how do you protect your inventions? Patents or trade secrets? There you have some choice. Part of the choice comes down to, once you get product into the market, can you maintain your secret? Often, once a product is out through good reverse engineering, somebody else will discover it, in which case you'd better look at another way to attack the problem, and that would be a patent. And if you satisfy the patent requirements, that again we'll get into, new, useful, non-obvious, in a later session, you can get a patent. The one background question to continue to ask yourself is, if it's going to take several years to get a patent, what's the life potential of the particular patent or invention you're looking at? When should you start trying to make this decision? Should you make it patenting very early, or do you work on other aspects of your company to decide whether, is there a market? Are you going to be able to get the product made? What are your supply chains? Again, a subject we'll spend more time on later. Basic line to me is, seriously think about patenting when you develop the product to an extent that you generally, not specifically, but generally know what it is. At that point, you also should be simultaneous looking at, am I going to be able to get this thing out into the market? Don't wait too long. Patent early when possible. It's worth it, if it's worth patenting at all. But what do you do if what you expect to patent is going to keep changing? That's not an easy question to answer. The simplistic answer is you file your one patent application and then you keep filing more and more add-on applications. And the cash register continues to go ding, 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 and what are those add-ons worth? If you can do it, the best thought is probably to figure out what's the core. Although a lot of the peripheral stuff may change, is there a central core that's going to run through your product line as you look forward for a number of years? And if you can figure that out and get a patent on it, you may not need to add on a lot of the extra stuff. And as one of the later questions will come up with, it asks, should I patent an improvement? Maybe you should, maybe you shouldn't. One of the questions again to ask yourself is, can I keep that improvement secret even though I've put the patent out there? Like most of these questions, it's not a simple, straightforward yes or no answer. What about licensing agreements? When do you want to get into them? One thing to remember here that is often misunderstood is, if I haven't mentioned it, I will, one of the biggest pieces of prior art is something that was, quote, on sale. Sale of rights in technology does not start that clock going. You can license, you can sell technology, you can license technology without starting the, hey, is it too late now to file my patent application clock? Is it wise to negotiate a licensing agreement before you file a patent? Normally, I would prefer to have a patent on file or at least written, so I know precisely what are the guts of what I'm going to license. It also gives the license some metes and bounds, and you avoid a lot of arguments later. Gee, if I just license my technology, what's all that? If I license a focused patent, that's something both you and the purchaser can look at and understand what's licensed. But the bottom line on it is going to come back to you, when do you need the money? What about IP? Should you own it, or should a startup get it assigned in by everybody? Preferably, I think you should own it. Your investors are going to like it better if you own it. You can do almost anything you want to by way of an exclusive license, but ownership has a cachet in the market the GM exclusive licensee doesn't. Probably the most important of this is, do you really control what can be done with this technology? Or if it's only licensed in, are there going to be, quote, discussions, close quote, with the people from whom it's licensed? Last question on this slide deals with, okay, what if the government comes in? Government-supported research is endemic to universities and to a lot of other places. It comes with a lot of strings and a lot of special rules of its own. Can you still get a patent if it's government research? Depending on what the deal that MIT or Stanford or somebody else cut, yeah, they can. It starts off with the individual and where do the rights get assigned. The fact that it's from the government doesn't mean you can't get a patent, but you're going to have to talk to somebody in some detail, given what are the grant situations and the government involved situations, on what can you really patent, what license is the Uncle Sam going to get back, and what rights will you maintain yourself. Can you automate? Tracking competitors' developments. I think I said last time that you really need to keep track of competitors, and I'll say more about that the next time we get together. If somebody out there is good enough to write the right program, I'm sure the answer is yes. If you write a program and you basically keep track of all of your competitors' published patent applications as they publish, great. If you know who the people are who are going to write papers, great. Those are going to be your two principal sources to keep track of what they're going to do. How do you choose? The question said which companies are best to acquire patents in. I made the assumption that what people are really talking about here is countries. The biggest thing in terms of countries, I've always thought are, is this a country in which the product or the service, the product particularly, you're going to selling is going to be made? Where is this a country in which there's going to be a significant market? Those are the countries you want to think about first when you decide where you're going to file a patent. I've dealt with a number of clients who really have kind of 2 or 3 levels of their patent applications. The short level, and I'm going back a few years, was typically the US, Canada, Europe, recognizing only some countries there, and Japan. That list has changed, and it gets larger as you get more and more basic on what is this patent really for. But I'll come back and say again, be careful. It is very easy to overextend yourself and spend too much money over too many years. What's a company do? The question says to use and markets policies all at the same time. I'm not quite clear what this question, what the basis of it is. It's a good idea on your secrets that people know what they are, and that the documentation that has them written down is marked company trade secret. Copyrights, you don't have to file copyright applications anymore. So other than the fact that marking everything copyright, which I suggest doing, the law doesn't require it anymore, but I suggest people look for that copyright symbol as an indication that somebody is or is not serious about trying to protect it. Apply for patents. That to some extent is the next time out. You don't want to apply too early. You don't want to apply too late. You certainly want to mark your trade secrets and start marking your copyrights right from the outset, but your patents may be able to wait a time. Med development startup wants to know, what do I do? I don't know much about this business. How can I reduce the risk? Not easy to do. You do know who your competitors are or will be, probably. You hopefully know what are the types of things that they are going to be interested in. You can run searches, but as I think I said last time, there's something like, you're always going to miss stuff. You're never going to get it all. There are probably now 5 million issued US patents that are still in force. You're not ever going to be able to search those. And you're not going to be able to limit your search to, gee, what's my new idea? Because you're inevitably going to use old technology to create your new idea, and that old technology may well be patented. And finding that is a horrible procedure. It's never complete, but some searches, keep your ears to the ground. Go to your trade shows, have people know what customers, competitors are talking about. Try to get a sense as what's sensitive for them. And those are the things you should think about trying to avoid. One question that basically came up is, it takes a long time to get a patent. 7 years for a patent to issue. Well, the patent office would like to make it shorter, and there are some paths in which you may make it shorter, but the statistics they put out are a little misleading, because what often happens is you file your first application and you run into a dead end. You're not getting anywhere, so you refile, and this goes on several times. But when the patent office puts together its statistics on how long did it take to get this patent, they only look at the most recently filed. They don't recognize the fact that you may have had other applications going back another 8 or 10 years. That clearly presents a risk for you, because unless you have made the decision that you are not going to seek a patent outside the US, your patent applications are going to be published 18 months after they're filed. Anybody is going to be able to look at them and read them, and they will. And they'll get information from those. What can you do to protect yourself from theft during that period? Unfortunately, I think the answer is not a whole heck of a lot. What you hope is that people who look at those and look at what you're trying to claim will say, you know, this guy was ahead of us. I don't know anything that's going to prevent him or her or this company from getting the patent. Maybe this isn't a place I should go, but that's largely going to be a decision that is made on the part of the person who's thinking about going there. Unless Somebody's got to, I don't have great ideas on what can you do to protect yourself from outright theft, because put yourself on the other side of the coin. If I'm a potential competitor and I'm reading this is free information, I can read it. All I have to do, I'm not stealing it, it's out there. All I have to do is decide whether it's worth the risk that it might sometime be patented, so maybe I ought to stay away from it. As we'll get into in more detail the next session, there are a whole different types of US patent applications. One of the things you'll hear about is provisional patent applications. What is a provisional application? Well, it's basically a stake you drive into the ground to give yourself, hopefully, an early date. Is it useful? Yes. Among other things, it doesn't count against your 20-year term. On the other hand, how useful it is really depends on how much is in it, how much does it or does it not disclose. I've seen a lot of provisionals filed because our chief scientist is going to give a talk at this great conference tomorrow and we don't have a patent application. What do? Well, what you typically do in that situation is you slap a cover sheet on the text of his talk and you file it that day before the talk is given. It's a great technical paper, but it's typically not a particularly great patent application. And later you may find that it doesn't disclose enough of what's going to be in your final application, which is the stuff you're really going to want to claim. A lot of patent attorneys spend a lot of money on provisional applications because what they end up filing is something that's almost exactly what they would have filed as a final application to make sure that it has all the information in it to support the claims, the scope of the monopoly they might want to get. This paper with a cover sheet on it often doesn't do that. One thing that people often forget about are the export regulations. These come up in patents because there's a requirement that you get a patent license before you file your US patent application abroad. You're permitted to file a PCT in the US without getting that license. But PCTs don't spring into other patents for the period of time. It's 6 months until you can file. So what you typically do is you file an application, you wait 6 months, you've heard nothing from the patent office, at which point you're now free to file. If, however, the patent office has a bell went off and they've circulated your patent application to various defense and other agencies, you may well get a notice and say, can't publish this, we're not going to give you a patent on it, we're not going to make that information public. And that gets probably most particularized today in a few really high-tech areas and things that people think are really national security. What you also have to remember, and tends to be forgotten, is that getting a license is very different from satisfying the export regs. Patent license and the export regs kind of run on their own two paths. And I'm sure most of you are familiar with the fact that the US has extensive regulations that have different groups of country to which different types of information can be excluded, or disclosed. And if you violate those, you're in trouble, but you're in trouble not only with the patent office. Your patent application, if you just filed it, that satisfies that part of the law. But if you do anything outside the patent route, you have to take a look at the export regs. And something I didn't realize until I've been around much too long not to have realized it, is if you have in the US foreign nationals working in your company, disclosure to them creates an export problem. Patent pending. You see it all the time. Why? Probably because a vast majority of the purchasing public does, or at least you hope they do, say, gee, this is a patent pending or eventually patented and allowed. This must really be special. It's marketing. Marketing, short and simple. But it also has something that may be more important from a protect yourself point of view. Is someone who sees that there's a pending patent going to be a little slower to copy your product than if they don't think there's one? I hope so. If there's going to be any significant investment for them to copy it, there certainly should be from their point of view. What it should do, if my marketing man comes in and says, gee, our major competitor just launched this product, we ought to copy the darn thing. It says patent pending. There's no patent yet. They should go look at your published patent applications and see, is there a risk? Hopefully it'll slow people down. And hopefully you'll also get more and more of the consuming public to buy it. Last question on this, I can't answer. I always had problems with this in 50 years of practice. What I have found is you have several different types of lawyers. You have patent practitioners who focus most on getting patents out of the patent office. You have technology licensing lawyers who focus most on getting agreements, getting companies and groups together to reach an agreement on where do they go. Almost any, even your patent lawyer can typically draft an NDA. They're fairly cut and dried these days, and what's in them is fairly well known. But if you get to a more complicated license, what you need, what you want, is a particularly talented licensing lawyer with IP knowledge who knows what has to go into those licenses, what are the IP issues that come up, but most important, what are the business issues? IP, as I think I said at the outset of the first session, is a business tool. Patents, they don't stand by themselves. They're not something that's out there by itself and you just want piles of them. Use them to promote your business, but don't confuse your business with your patents. Cost. How much does an attorney cost to write it? Answer, it may cost a lot. You may be able to get very good service for less than some of the big major firms will charge you. What you're looking for is a good patent attorney. You're always looking for a good person. And there are people who practice solo or in small firms who do an extraordinarily good job that don't have to produce the level of profit that a major firm is looking for out of all of its levels. If you're getting into a bigger, broader structure like licenses or perhaps litigation, you probably do need to look at the broader group of lawyers. But you can do some shopping around and find often a very good lawyer who will not charge the better part of $1,000 an hour that my time went out for just before I retired. On the other hand, there are times when you pay for what you get. So you want to be able to evaluate what whoever you're looking at's work looks like. And that, again, is not an easy thing to do because it all looks good until something goes wrong. But look at some of their issued patents. Think about them. Think if they're any good. Maybe you want to be really far and look at what happened to some of those in the patent office. Did the patent attorney just cave in and accede to everything the patent office asked? Or is there a sign that the patent attorney really had your business in mind when she or he was making the decision of, I've got to fight on this? Will they accept equity? Most firms will not. Some individuals may. I agree it's good to have a vested interest. Can I write it myself? The answer is you can, but I'm not sure I suggest that you do. But that doesn't mean that you can't significantly reduce your costs if you do a lot of the basic technical writing yourself. Most of you have seen a patent. There's the drawings at the front. It then has a long discussion of describing what's in the drawings. And then it has that a patent lawyer's Shakespearean sonnet called a claim at the end. You can write most of that intermediate technological area. You can save yourself money by doing it. And perhaps even more important, you can make sure that the important technology is in that application and something doesn't get lost in translation between you and your patent attorney. I've seen too many instances in which something was important and for some reason never made it into the filed patent application, and people live to regret it later. There's also a famous story of somewhere in a patent application was, I haven't read this, but I signed it anyway, buried in the middle of the text, and that didn't even get taken out, and the guy signed it. Litigation costs. Litigation costs are also horrendous, which is why I started off last time, and I'll continue to say, avoid it. A license is certain if it's one you can afford. What's litigation going to cost you? It depends on how much is really at issue. The American Intellectual Property Association puts out a survey every year or so. Their estimate is that if you've got less than $1 million at issue, and that's a small case, it'll cost you $400,000 through discovery and $500,000 through trial. That's 60% of what the value is, assuming you win. And in this country, unlike a lot of countries abroad, everybody normally pays their own attorney fees. You don't recover from the other side unless it's what's called an exceptional case, which basically means everybody decided that one side or another, frankly, was almost in bad faith in either bringing or defending it. If you've got as much as 25 million at risk, it's very easy to spend well over half to 5 million. And I don't even want to guess how much Apple and Samsung have spent in their worldwide wars. It's clearly millions and millions of dollars. Is there data available on outside the US? Answer, yes. I just did a little quick searching around. One thing you have to keep in mind, particularly outside the US, is that litigation is often two-tracked. A court will handle infringement, but the question of patent validity is not handled by the court. It goes back to the patent office. So you have not only the court case, the infringement case, which often may be the cheaper of the two, but also the infringement, which is more likely to be expensive. In the US, that used to be the case, that it was always first decided by a court. That has changed over the past 10 or 15 years because the patent office has established some ways that you can go back in and get the patent office to look at should this patent have been issued in the first place. If you do that, you're going to spend the patent office money in addition, and it's very easy for that to run up to the better part of $500,000. But on the other hand, if it saves you $5 million, that's a fairly good investment. But it may not save you the $5 million. You may have to go spend that in addition anyway. Japan, figures I saw, it'll run anywhere from $300,000 to maybe $1 million in a really expensive case. Germany, I found a breakdown. The invalidity action may run $75,000 to $100,000, but the infringement action seems to cap out at about $100,000. Cheaper than the US, yes. Penny ante, no. Can I monetize my patents? The answer is yes, but it's not easy. Because anybody, the quickest and the easiest thing you can do probably is to use them as security for something or collateral, because often then somebody just wants all the assets you have in that collateral basket and doesn't bother really to validate or figure out what they're really worth. But if you want to monetize a patent by selling it, the buyer is going to make the same analysis you did. What's the market value of this thing? What's the technology worth? What's the market worth? If you don't think it's worth enough to keep yourself, ask yourself why. Is it because of the value of the technology? Or is it simply you've decided that's an aspect that you just aren't interested in, you're not going to pursue. If the latter, somebody else may want to, and hopefully it won't be competitive to you. You can monetize, you can evaluate, but again, get some people who have done a lot of this to help you out, and unfortunately, I'm not one of them. Let me slightly change the trade secrets. And basically, this gets back to the idea of agreements. Question is, how do you make a non-compete or a DNA bulletproof? Well, I or an awful lot of people can write you an agreement. The agreement itself looks pretty well bulletproof. NDA always has a problem because it's supposedly protecting confidential information, and you're going to have fights with that if you get into one. Is this really a trade secret? Is this really something that should be protected? That's why non-competes came into effect, because even under the new Massachusetts law, you can get a non-compete with somebody who has a lot of your information for a year, and you can get one for 2 years in most other states, and you don't have to prove anything in particular is a trade secret. One of the problems comes up, obviously, if you go to a manufacturer who's going to make prototypes. What do you need with them? You need to talk to them. You need them to agree to keep things confidential. You need them to agree only to sell to you. And frankly, you've got to trust them, which is probably the most important. People are what you're dealing with. One thing you have to be careful of in that agreement is whether or not what they sell you, your prototype that they sell you, does that start the 1-year clock? Is that a public on sale that makes it too late to file a patent application? The US law at the moment is less clear than you'd like to be on that. There are cases that say there are other cases that say this wasn't really a sale, it was just for engineering purposes. It very much depends on the agreement, and it gets a lot more complicated than a simple NDA. What secrets are included within the realm of trade secret? Definition is anything that gives me an advantage in my business. Should you just have that as an understanding or an agreement? Have it as an agreement. And have it as an agreement not only with your employees, but also all of your consultants. And frankly, if you get back into a situation where you're a startup, how do you handle the founders who are bringing things to you that presumably, at least as long as your new company is afloat, they're perfectly happy to be the new company's trade secret, but how do you deal with them? And if you're one of the founders, how do you want to be fairly dealt with if you want to leave the company or you want to go ahead and use something outside the company? But damn it, I came up with this idea first. Virtual environment for innovation, registration process. Well, you've seen every time you pick up a program, you go into Apple or anything else, click if you agree. Those are legally enforceable. Nobody reads them. If you want an enforceable NDA, get it in paper. At least the person you give it to is going to read it and think about it, whereas the click, they won't. And do they read it and think about it? Is that important? Yes. There are thieves in the world. No question about it. But there are also a lot of people who will inadvertently disclose, who might not if they really realized, if your culture was such that you made sure that they realized that this is important information confidential to the company. Same thing when you're talking about your scientific staff. Last question was the assignments. I put a couple of samples up in the last session. And this, I went back and looked after I got this question, it seemed to include IP created by others. I think what I said was it was IP in the agreement created by me either alone or with others. Sure, I don't assign what somebody else have rights in, but this is to take care of the situation where there are multiple people who are involved in the idea who came up with the technology. Improvements as trade secrets, I touched on this a moment ago. I've made an improvement, but I got a good patent. It covers the improvement. Do I have to apply for a patent on this improvement, or can I keep it as a trade secret? Seriously consider the latter, particularly if your core patent has a long time to run. Do you really want to spend another 60,000 plus on a patent on just an improvement? It can be an important improvement. Also ask yourself the same question you do with every other potential trade secret. Is it going to remain secret? Or am I going to necessarily have to disclose it? One of the problems with keeping things a trade secret, and we'll touch on this later when we get into patents, is if you are practicing a trade secret, armed guards around your plant and anything else you want, what you're doing is not prior art to anybody else. So somebody else can get a patent on your trade secret. What happens then? Here you've been selling Coca-Cola for over 100 years. Somebody else independently comes up with the formula, although it's probably not patentable, let's assume that they do patent it. What's Coke gonna do? Until fairly recently, the advice you always gave in this country is, yeah, they can stop you because there's no prior art. There now in this country is a rather limited section that provides that you can continue, if you commercially used it, starting at an early enough point, but the real questions as to whether you can, extent to which you can expand that use. This is still a risk in the US. It's not as big a risk it used to be. It's less of a risk in a lot of other countries that frankly have broader defenses on the, hey, I've been doing this first. They may keep the patent valid, but they won't let somebody assert it against you. Trademarks, domain names, etc. The big difference, and I hope I mentioned it earlier, between a trademark and a domain name, 2 or 3 differences actually. The first one is that trademarks are always associated with products or services. Different people can have the same trademark for different services, for different products. An example I probably used before was Cadillac cars and Cadillac cat food. For domain names, nobody cares about the services. The question is the domain name registration or the Secretary of State's office where you registered your company name going to hiccup because it has 2 Cadillac companies? Domain names have to be different, not in any significant way, but they have to be different so something doesn't hiccup. Trademarks, for somebody's trademark to avoid you, the difference has to be that the marks themselves, at least when associated with the goods, won't be confusing. In recent years, the domain name people have gotten a lot better at people who adopt a a domain name simply for the purpose of getting somebody else's goodwill. And they're beginning to clean the register of a lot of those, but there's still some out there. Moving on, the Madrid Protocol. Madrid Protocol, some person who asked this probably knows more about the whole subject than I do. There are a lot of countries that belong to the Madrid Union. I clicked on this weekend and it said there are something like 101 members covering 117 countries. That's a whole lot. And if you can use the Madrid Protocol, you can start to get protection for a lot less money than it would cost you to go into countries individually. The hiccup, and I think it's probably behind this question, is you've got to do that within 6 months after you file your initial US application. What do you do after that? Well, after that, you've got to go back to the old tried and true country by country registration. And yes, there is a list. Some require you be the first to file, and some require you to be first to use. Much too long a list to print here, but if you Google it, you'll find it. Software. In the last opening session, I put up two cases, software cases, Lotus v. Borland, and Google, and the Google, wait, John, who's the other person in the Google case? Okay. Okay, these were software cases. These were questions of, okay, did somebody infringe a software, infringe your software copyright? All of those cases also, not the Lotus did not, but the second one clearly also involved patents. What you can patent and what you can copyright in the software area, there is an overlap. Namely, the overlap is how much is it for hardware or software versus hardware? How much is it for simply the code? Then you get into how close do you get back to the idea? The US, as we'll get into, I guess, 2 sessions out, has gotten fairly tight on what types of software it will patent. Oracle and Google. Thanks, John. The EU, the EU itself says computer programs as such are not patentable. Don't stop there. Because computer-assisted inventions are, so they shove them all into that category and leave keep the idea of what's prohibited as patenting is simply the printout of the software or the code. So you can patent algorithms and software solutions if they're part of something you're doing in foreign countries. The code itself is pretty much limited to simply copyright. Business processes, that's a big fight in the US these days. Until the late 80s, it was fairly clear to most of us that you couldn't patent a business idea, even if you used a computer to do it. That rule started to change, and the pendulum's now swung back the other way. We'll get to that in some detail when we get later. What's a business model? What's a business patent? Probably not patentable. People look very askance at just, this is an idea of something. This is just something you want to do without exactly how are you going to do it. The description, the book you write, and how you're going to do it can be copyrighted. But one of the problems with that is the copyright only covers the way in which you describe your idea and not the idea itself. So I guess come on back and we'll play some more games with what are the lines on patentable software solutions in the US. As I said in the earlier session, there is a really big outstanding question on what types of code can't be copyrighted because frankly, they are too useful and nobody reads them for how well they look or sound. Can a code be copyrighted? Sure. Can software, they're probably not patented per se. Software, can it be patented? It depends. Can hardware? Almost certainly. Simple dividing line, if you're looking at your software and can I get a patent? Are you using a computer simply to do something that if you had thousands of years and hundreds of thousands of people, you could probably do with a pencil and paper? Or are you using it to make the computer work better? If the latter, it probably falls into the category of patentable invention. If the former, current law, at least in the US, pushes the other way. My guess is that the European law is somewhat in the middle because these patents are always written that they sound like machines and they don't go to the sorting methodology that the US has done. Common IP issues around software development. If you want to talk to somebody in detail, you're going to have to find somebody else. We've got limits on how much time, frankly, you can even spend on that subject here. You obviously have problems on that. Did you use open source just to get completely out of the patent? Are you using anybody else's source materials? Typical with any copyright, where did your ideas come from? To what extent Are they all yours? What's the implementation? Is it a useful implementation? It's a very big subject. A, I'm the wrong person to get into it in detail, and B, it would take a lot of time. If you've really got to get an answer to this, find somebody who's in the software copyright area. And there's some people all over the country. I know some, actually all over the world. I know some here, but probably not a too old patent attorney. Patents and copyright. How do owners' rights differ? We talked last time about how important it is to making sure that you are the owner. In terms of how do your rights differ, the basic difference between them is what rights does a copyright give you versus what rights does a patent give you. Copyright, requires copying. Two people theoretically could write identical Romeo and Juliets, and if they didn't copy each other, both of their copyrights are completely valid. On the other hand, if it's a patent, first one in, patent doesn't cover the expression of the idea, the Romeo, Romeo, wherefore art thou? It covers the basic idea itself. Romeo and Juliet is a lousy example because there is no technological business idea behind it. But copyright, remember, sits on top of the cake. It's the icing. When you're after a patent, what you're really after is trying to get rights in the cake itself. Which says, how do you copyright a plot such a Romeo and Juliet? You probably can't, because that plot's old at this stage and everybody knows it, unless you somehow sat down and wrote the whole thing yourself, though I think the Copyright Office would probably say, who are you kidding? Of course you copied this consciously or not. But on the other hand, you can write a lot of different stories, a lot of different plays that play on, bad choice of words, the same boy meets girl, she's of one culture, he's of another culture, families are at war with each other, fall in love. One of them kills the other then goes ahead and tries to kill themselves, et cetera, et cetera. There are a lot of books that have, a lot of plays that have that general theme. And you can copyright your book, your play, your poem about that. Yeah, you could create a comic book or a lot of other things with a similar plot. Digital music. Everybody who's in that business recognizes it's a horrible problem, that nobody who is the artist is getting anywhere near the recompense that they should be. How is it being solved? Well, you've got a couple of big organizations, BMI and the Harry Fox Agency, that do an awful lot of work for people who are trying to make money out of that. If you go to their websites, they'll tell you exactly what they will do. Some of them are more on the performer's side. Some of them are more on the who wrote the musical composition side. They're doing a lot and they're working on it. There was a bill filed in the US Congress a few years ago to try to deal with this. Unfortunately, I don't think it's gone anywhere. And on a quick run through on a computer Google yesterday, I couldn't find anything new and recent that's going on. My assumption is there are a lot of people talking on it, there are a lot working on it. At the moment, the best solutions are probably going to come out of private organizations such as Fox and BMI. Congress never does anything. Then we get to the question of recording, and this kind of wraps up a little in the same idea that you have the underlying composition and you have the rights of the person in his or her performance. Can the owner of a recording, let's take the record in this point, or probably the disc, nobody has records anymore, hold all rights to the recording? The answer there is no. Just remember, if fact that you buy a book doesn't mean you hold all rights to the material in the book. People may not know who that copyright owner is, but they do know that it clearly is not you. Does that mean you can probably safely do things with it unless the copyright owner comes up and says, hey, stop what you're doing? Real world, without a copyright owner, there's probably nothing to stop you, but don't fool yourself into thinking that you really own things. Patents international. There are all kinds of international conventions. There are copyright conventions, there are patent conventions, there's several of them. The patent conventions, particularly the PCT and the European Community Convention, keep really good records of when patent applications were filed, as does the US. I don't think for them to verify the priority date of when something is filed is not something I've run into as a problem. The problem that comes up is when you get multiple filings, is a later one entitled to that earlier filing date. That requires a comparison of the substance of the two. But simply when was the first one, the second one, or the third one filed is probably not too big an issue. If somebody has run into a particular problem on that, I'd be very interested in knowing what it is, because I'd sure go back and take a look at it. But it's not one that I've run into myself. Is there a global patent? Unfortunately, the answer is no. Patents at the moment are country by country. The European Union is sneaking up on a European patent. They've been sneaking up on it for probably 25 years. They now may be getting fairly close, but even there, the best, and that's about the best that you find. The procedure is you go to a central patent office who approves the patent, but you then have to take it down and get it registered or validated in each country. Worldwide PCT, you can file a PCT, and frankly, you can check off countries you've never even heard of. But eventually, if you want patents in them, you're going to have to file applications there. And the obvious answer is, the patent in my country valid worldwide? No. More interesting, or actually more difficult question is, what do you do? We'll get where situations where you recognize that there are companies with weak patent systems and companies with strong patent systems. How do you, I'm going to move on to the next slide, because there's a lot of that, we'll come back for a second, that deals with that. How do you deal with those, and how should you deal with them? On the Tanzania example that was on the previous slide, is the question whether Tanzania has a strong patent system, or is the question whether the fact that it doesn't has a strong negative effect for any Tanzanian who's seeking a patent in a country where, frankly, the markets, et cetera, are going to be bigger? Or does it really matter that Tanzania's system is weak in the overall view of a company that's trying to sell worldwide? As I mentioned a few minutes ago, the usual procedure for companies with IP is to patent where it's going to be made and where the biggest markets are. You simply can't afford to seek a patent everywhere. You have to recognize that there are a lot of countries, typically small ones, unfortunately, there's also some big ones, where your ability to enforce a patent is fairly questionable. Do IP systems benefit developed countries? If they're not, there are an awful lot of people who are spending a hell of a lot of money on patents and patent systems in the developed world. People think so. People think that having strong IP systems encourage investment and thus encourage new ideas to come out and make it to the market to the benefit of everybody. Sure, disclosure of technology invites competition, but it invites competition in places where you don't have a patent or probably can't enforce one, and you hope those are relatively small parts of the market you're looking for. Does it benefit the issuing country? Yes, if it benefits the economy and the manufacturing of companies in those countries. How do you prioritize? You look at the things that you came up with. What are the markets? Where can you afford to put your money? Recognize there are places that really doesn't make any sense. Global patents, there'll never be one. People will never agree on what the standard should be, because they vary differently. They vary on subject matter. India is very tight, for example, on a lot of medical and personal uses. But But a global central filing system might make sense, but frankly, we're sneaking up on that with the PCT. The fact that patent applications can be accessed from anywhere in the world via the web, does this put a country with a strong legal system at economic disadvantage? What it does is it enables, for example, somebody in Tanzania to get information that he or she probably would not easily access if patent applications weren't published. Will that long run be a benefit or a detriment to the Tanzanian economy or to the person who really came up with the idea? I could argue that one both ways. I really don't know the answer. Well, I now have about 3 minutes of 12, and I think we have gone through the better part of 75 questions. And anybody out there who has another one, would like to ask a new one, or thinks I just blew it on my answer, chime in.
So we have quite a few questions. One specifically is from Peter Flores, who asks if you can expand on the strategy and cost-benefit analysis of having a patent. Should attorneys or engineers lead the tax value from this process?
Should engineers or attorneys, what was the second part of it?
I think what he's really asking here is who leads this patenting process? Is it the attorneys or the engineers or both?
You need both. Don't let your attorney decide what patent claims are good for your company or for your product. They aren't your marketing people. They aren't your scientists. They depend on you for that information. You have to have good communication between both. Because otherwise, how's the attorney supposed to know what is or is not valuable to you if they don't know what your marketing plans and products are? And how are your scientists supposed to, or marketing people supposed to be able to make the judgment as to, is this really what we should be doing if they don't have a basis with the help of the attorney of are we going to be able to get patent protection? People have got to work together on this. We'll get a lot more into this. I guess it's the next session, not the second one now.
Okay, so the next question from Nitesh gives an example. SpaceX does not apply for patents. How do they, or will they, ensure that their technology doesn't get stolen in a case of partnerships?
Who is going to have access to their technology? Are there space products such that anybody can go up and grab a rocket out of a satellite out of the sky and back engineer it? If the answer to that is yes, you have the normal risk you do with everything else. Otherwise, not stealing your technology really comes back to limiting disclosure of your technology to the people who really have to know it, making sure you have good non-disclosure agreements with those people, and making sure that both you and they have a common understanding of, look, this is the type of stuff you can't talk about. Confidential information doesn't include where's the cafeteria, but it does include what's the secret sauce. You can't walk out of here with a list of my formulas. And I've had cases where people have done that.
And he follows up to say, I'm working on the area of desalination. And it's a little bit more down to earth, not in space. And so
it's all wet.
So the question is, how do you have more airtight agreements?
I think the answer is really pretty much the same. The biggest thing to remember, well, again, too, where's your product going to go? If you've got the product out there, if I buy one, am I going to be able to figure out what you're doing? If the answer to that question is yes, you've got lead time, but you may not have a whole heck of a lot more. If, on the other hand, I can't back engineer it, if you don't disclose it to somebody, they won't be able to copy it. If you disclose only parts of it to different people, it's going to be a lot harder. I may have told the story on my understanding of the way Polaroid, when it made its color film. The people who made that film got different colored 55-gallon drums of liquids. They were never told what was in those drums. All they were told was to mix, and I'm getting a little facetious here, 3 black, 1 red, and half a yellow. Compartmentalize. Don't disclose.
One final question from Otto. He says, I've developed a voice over IP system that's the telephone system that runs over Ethernet or the internet. And that will give my company a competitive advantage as long as no one else copies it. So the problem is the functionality it provides once it's published. It's relatively easy to copy. For example, think about the Amazon one-click purchase button. And
which is patented.
Sorry?
Which is patented.
That's right. So the question really is,
it should be is a different question, but it is.
Will it be possible to file a business method patent for using the system to enable that functionality instead of filing a utility patent on the VoIP system itself?
Okay, start off with one of the problems with business method patents is they are utility patents. That's the category. They're not design patents. They're not plant patents. And our categories are plant, utility, and design. What you are patenting is hopefully not simply the functions, but what have you done new that enables those functions? That clearly should be patentable. Purely functional, if all you're saying is do A, B, C, D, E, and any computer can do it, the way the present law is, you're going to run into problems. But if you're going to say, to be able to do this, I have to be able to provide functionality, and how do I provide it? You're playing in an entirely different ballpark.
Great. Well, thank you.
Thank
Jim.
you.